If you didn't know this, there's no duty to engage in fair negotiations in the criminal justice system. Really strange and frustrating for everybody because prosecutors hold so much power that they can literally just kind of pretty much do whatever they want. There's nobody that they really answer to. We got the craziest response from this prosecutor where our client's charged with a DUI and we're asking for reckless driving. And so we write a letter called a deviation letter saying, hey, here's all the problems with your case. Here's, why this person deserves a reckless driving, a lower level charge. And, we'd really appreciate that. Work with us on that. We do this all the time for our firms, for our cases. There's a lot of law firms that do this as well. The prosecutor responded and said the deviation is denied. And one of the things that our law firm does is we follow up. And so one of our attorneys followed up and said, I appreciate that you responded and denied our request. Is it possible to get a more detailed response as to the reason for your denial? Thank you in advance. The prosecutor responded back and said, no, it is not possible to get a more detailed response. This is, again, just the very frustrating part of really the criminal justice system and how much power these prosecutors have. They're not accountable to anybody. They don't have to answer anybody's questions. They can really do whatever they want. And anything outside of the courtroom, such as negotiation, don't have to be fair. And they can really hold a lot of power in these type of situations, in these negotiations. The really sad part about this is we as defense attorneys, them as prosecutors, we all work in the justice system here. And so it's very common, very normal to engage in negotiations. It helps prevent cases that shouldn't go to trial end up in trial. It helps us get, innocent cases dismissed. And so there's a lot of very good reasons to do this. But if the prosecutor wants to be an asshole and just say no and not give a single reason why, they're allowed to. And there's no law, there's no judge, there's no nothing that's going to change that. It's really a culture issue for prosecutors where they think they have so much power, their ego is so big that they don't have to answer questions or explain themselves in any way, shape, or form. And that really just leaves you the defendant who's fighting your case, just to fight your case and to go to trial. And there's no other option. There's no negotiation. You are going to get stuck with a plea deal potentially that's not even good and is not even appropriate. Prosecutor wants nothing to do with you. And that's the reality of the way that it is. Now, what's crazy is if you are following this and want to hear it more, this prosecutor said, I've never had any other firm ask for a more detailed response when we deny a deviation. But I often get that response for your firm, which is great. That means that our firm is doing what we should be doing. They said it might be easier just to ignore it, but in the spirit of open communication, this guy believes in the spirit of open communication, I wanted to let you know that I likely won't be responding to that kind of request for an explanation and don't believe that my colleagues here, so the rest of the prosecutors for this whole town and cities in Gilbert will either. I don't think it's an appropriate request. We don't need to give more details and won't be. There's a lot of truth to what they're saying here. They're not required to do anything, but in the spirit of open communication, there's nothing inappropriate by asking, hey, can you explain why you denied our request for a lower charge? Can you explain, what about the deviation, the mitigation, the legal issues, anything in here that you maybe didn't find as appropriate or we thought was a really strong case for us, but you think it's actually a really strong case for you? I responded back saying, hi, Mr. Prosecutor, this is a requirement for our firm for all of us who submit deviation. The idea behind this covers a few different things. We've had deviations denied when we asked for more reasoning, we find out that the prosecutor was actually looking at the wrong case this whole time. And this actually happens like every week. A prosecutor says, no, this is denied because, your client, punched through a wall. And it's like, wait a second, our client never did that. You must be looking at the wrong case. And then they respond back, they're like, oh yeah, sorry, I was looking at the other, Juan Garcia case, right? The other Michael Johnson case, because there's so many people who have common names here, like prosecutors get it confused and mixed up. So I continue on, I say, obviously these kind of things happen, but we really don't know unless we hear back on why a deviation is denied. Another reason why we asked is we found that it actually helps us that we can identify the main issues that are in each case. For instance, if our deviation is denied due to specific reasons, we can now note that for the file and not keep asking you something better without giving you a different problem in the case or additional mitigation to present. This is kind of the problem problem when you just say the deviation is denied, because it doesn't really tell us what we can do to overcome that issue, which is preventing the deviation from being approved, if at all, right? And so a lot of the things we talk about in deviations are, hey, the reason that the police officer pulled this person over was not valid. And if that's not valid, then the whole case needs to be dismissed. And so in exchange for going through the whole court process, the whole trial process, we would just like a lower plea deal, such as, say, reckless driving. There's a lot of issues with the alcohol levels, maybe on the lower side of things. There's a lot of issues with, say, Miranda rights violations, a lot of negotiations that go over these type of things. And when the prosecutors respond to us and they say things like, hey, actually, we double checked it and we believe that this is actually really strong for our position, our prosecuting position, because also, while yes, that may be true that this problem exists, your client, the defendant, admitted guilt to this. They were swerving all over the road, were stumbling, they had open containers in the car, right? And so they can point out other things that help their case. Really deflates our defense. So again, this is part of why this is used. And continuing on with my letter, I say here, if we get a reason why the deviation is denied, then we can specifically tell our clients that that is the problem and really tell them that they might not have any chance at being successful at trial based on what you bring up in your email. However, when we bring up valid legal issues to our clients and then you give us a general denial and then we update our clients, it's significantly less impactful because our clients seem to think that there are these major issues in their case and there's nothing that you think is wrong with it, which means they have a better chance at winning the trial, which obviously is untrue. We just don't know what the prosecutor's holding on to. And finally, we ask for specific reasons for denial because we put hard work into our deviation. We don't just copy and paste deviations and we don't just send one-line deviation emails. There's a lot of defense attorneys and prosecutors that'll just say, hey, we want a reckless driving, will you give it to us? ? And it's very common in those situations for the prosecutor just to say no. And now if we were to ask like, well, why not? Well, that makes sense. We didn't really put anything behind why they should give us what we want. But we continue on, I say, but when we put all this work into deviations, then we get a one-word denial response. It comes off the wrong way, basically as if the state has nothing better to do, such as engage in negotiation. And so again, it's just really a lack of respect. These prosecutors think that anything we say means nothing, and there's nothing that, they've ever done wrong. They know that they've never made a mistake, and so anything we ask for is just a simple no, and they don't need to explain themselves. It's very unfair negotiations because, again, the things that we bring up in our negotiation tactic are very legitimate issues, right? There's significant problems with cases. There might be also maybe no legal problems, but a ton of mitigation. I mean, this person could be like a reincarnated Mother Teresa and doing all this amazing things in the world and have a 5-minute mistake. This is kind of like the celebrity defense that comes up. And those work. Prosecutors do give better deals for those situations. And again, prosecutors need to acknowledge that their case may not be as perfect as they think it is. Prosecutors don't ever think that the police do anything wrong, and the police do things wrong in almost every single case. We identify a lot of these things and send it over in these letters, which takes a ton of time and a ton of work. And they're usually very successful until you get a prosecutor like this who's just kind of an asshole and says, nope, denied, and we're not going to explain why. Continue on in the letter, I say, overall, I appreciate that you guys gave us more of a detailed response in that you will not give us a more detailed response. That's my way of being witty on this, I guess. We understand that your office will do as they wish on this, but since our firm requires us to do this, we will keep asking for more details. And if you simply respond that you don't have anything else to add, that is what it is. Hopefully one day things will get better on the negotiation front for the sake of fairness in the justice system, as we're all working on these cases and it doesn't have to be so adversarial. This is basically because these prosecutors have a higher ethical duty than any other lawyer because of the impact of the work that they do. And the prosecutors are supposed to be neutral purveyors of justice. That's essentially, one of the legal terms. A neutral purveyor of justice basically means all they're seeking is justice. They have no skin in the game. They don't care if a case gets dismissed or if somebody gets found guilty because justice at the end of the day was served. And when they respond to things like this, where they won't even engage in negotiations, when they won't even say how strong their case is or how weak their case is, it's clearly because they have a personal bias. They want to be right. They don't want to be wrong. They are not a neutral purveyor of justice. They will get a conviction at any cost, even if they convict innocent people of crimes. They just really don't care. And part of why this is really crazy is because being a neutral purveyor of justice means, and part of why you're even allowed to charge a case and what beyond a reasonable doubt means as a prosecutor, is you know and believe that your case will win beyond a reasonable doubt at trial, or else you really wouldn't have charged the case. You wouldn't pursue a trial resolution in this. And so for them to turn around and be like, we're not going to tell you anything about this case, to another lawyer, a professional, it very much is very strange in this, like, wait a second, like, you should be so confident in your case that you go and tell every defense attorney, by the way, I'm going to convict your guy because I got this proof, this proof, this proof, and this proof, and there's nothing you can do to talk me out of it. But instead, what these prosecutors are doing is they're simply just saying, you don't know what proof I have, and I'm going to keep it all locked up here, and then boom, if we go to trial, I'm going to release it all, right? And again, legally, they're allowed to do this. There's no legal requirement that they disclose anything about their case other than what is legally required, essentially the police report disclosures and anything maybe truly to prove innocence. This is basically where they sit here and they go, I'm not saying anything about my case, I don't have to, and we present very valid issues and they don't bring it up, or they don't acknowledge it, and they don't have to respond to it. And they get these attitudes that say, we're better than you and we don't have to respond to anything with other than a simple denial. That's what we get to deal with. So again, if you think that the justice system is fair in any way, it's not meant to railroad you into a conviction. Prosecutors can pretty much do whatever they want. It's not a fair fight. And this is really why even like having lawyers doesn't guarantee you get a case dismissed or guarantee better results, but it is the only way you get better results. And that's very important to understand with this.